very good morning, ladies and gentlemen, and welcome to today's webinar on UAE labor laws. My name is Lydia Bummeltiagi, and I'm working as an Executive Director for the European Enterprise Group and Marketing, and it is my pleasure to be the host for today. We all know that the UAE has a new set of labor laws governing private sector employment relations. On February 2nd, 2022, Federal Decree Law number 33 of 2021 took effect and replacing Federal Law number 8 of 1980. I'm very pleased today that Piyush Pandey, Senior Partner Legal Advisory, and Sakina Dekanwala, Associate Partner Legal Advisory, will brief us about the new amendments. So let's have a look at the agenda for today. So for all of you who don't know us yet, I will give a very brief introduction about MBG Corporate Services. Then my colleagues will talk about the new labor law, what you need to know, key amendments under the new law, employment contracts and working models, employment termination under new law, gratitude, the non-compete clause and new initiatives. And then we'll end the same with the question answer. So if you have any questions during this session, please feel free to drop them below and we will either address them live today or we'll get back to you all individually. So just to give you a brief introduction, MBG Corporate Services is an international firm headquartered in Singapore with currently 18 offices spread across 8 locations in China, Japan, Singapore, India, Germany, Qatar, Oman, and here in the UAE, where we have 300 professionals working out of offices in Dubai, Abu Dhabi, and Sharjah. We are privileged to work with more than 3,000 clients here, out of which more than 100 are Fortune 500 companies. We provide services at every stage of their company's life cycle, so right from any kind of market research, feasibility study, structuring, market entry, company formation, across the entire life cycle up to extension and expansion and liquidation plans. We do this with 8 in-house verticals. So the traditional audit and assurance practice, we are appointed external auditor for all mainland and free zone entities. We have been working as a partner for the National In-Country Value Program, so we are an official certifying body for this. Further, in terms of risk advisory, we provide services around drafting of standard operating procedures, internal audit, AML, ABC, enterprise risk management. We are a registered tax agency with the federal tax authorities to support our clients around VAT compliance, VAT health check, excise and customs services. With the introduction of corporate tax in the next year, we are very privileged that we already have a direct tax vertical here stationed in the UAE, which is currently helping a lot of our clients on the corporate tax introduction. In terms of M&A, we support our clients on buy as well as sell side. We have an in-house legal team, which of course Piyush and Sakina are representing today. So they do work, of course, across labor law, contract management, PRO services, liquidation, corporate secretarial services, etc. And then strategy and transformation, where we advise around cross-border expansion, market entry, feasibility study, and technology advisory, where our team looks into IT audit, cybersecurity assessment, or even robotic process automation, where we have companies with large number of transactions to automate these. Our clients are spread across diversified industries, so generally we work sector agnostic, but of course we have our subject matter expertise who has deep experience in the leading sectors here in the UAE. With this, I would like to introduce the first speaker for today, Mr. Piyush Pandey, who is Senior Partner for our legal services. He's a law graduate and fellow member of the Institute of Company Secretaries of India and has over 18 years of experience in dealing with matters pertaining to corporate law, capital markets, financial services, due diligence, M&A, takeovers, private placements, financial restructuring, debt, loan syndication, etc. He has an in-depth understanding and experience in managing capital, commodity market operation, compliances, funds, planning and arrangement, dispute resolution, and many more. So Mr. Pandey, over to you, please. Thank you.
Thanks, Lydia, and good morning, ladies and gentlemen. Welcome to our today's webinar. Today, me and my colleague, Ms. Sakina Dekanwala, we are presenting very interesting topic covering newly introduced labor law. So in the recent past, we all have seen the government of UAE has taken various regulatory and policy reforms so as to make UAE a preferred destination for doing business. And this is another welcome step, another welcome initiative taken by the government to create an efficient labor market in the UAE, as well as to promote and regulate the labor relations in the UAE. And it will be quite helpful for the businesses to attract and retain the best talent from across the world. So basically, it was very much needed. It was very much warranted, because if you see the previous labor regulations, it was enacted way back in 1980. So almost more than 4 decades have passed. And as we all know, during these 4 decades, the entire business environment got changed. Now there is a concept of global economy. So businesses went global. They don't believe in the boundaries. And recently we have seen the UAE government has also opened its economy for foreign direct investment in almost all the sectors, except very few which are of the strategic nature. So what does it mean? It means more and more foreign capital will come into the country, more and more foreign investors will come into the country. But once a foreign investor decides to enter into any other country, then it evaluates the business environment in that particular country on the basis of various ease of doing business parameters, whether there exists a robust infrastructure, whether there exists a effective business ecosystem, whether there exists an effective mechanism for enforcement of the contract, whether there exists a effective legal dispute resolution mechanism, where there exists effective regulatory mechanism, compliance mechanism, corporate governance measures as per global standards. And on the top of it, it inquires, it evaluates whether there exist effective labor regulations in that particular country, and whether there is availability of the skilled manpower in that particular country. Because ultimately it is the manpower that drives the success of any business or any industry. I think you must recall during our academics time, we have been introduced the concept and power of 4M. First M stands for the manpower. Second M stands for the money. Third M stands for the material, and fourth M stands for the machine. So, and you can see the manpower has been ranked on the top of all these other factors, because ultimately it is the quality of manpower, skill of the manpower that drives the rest other factors for the growth of any business. Because you can infuse billions of dollars into your business, but if you're not having the skilled manpower, then what will happen? Either your money will lie idle into your account, or it will get eroded. Similarly, you can procure best quality raw material. You can install best technology machine for your industry, but if you're not having skilled manpower, then of course it is of no use. It will not yield intended result. So government has recognized all these business needs, and it has taken this initiative to introduce the new labor law by way of Decree Law number 33 of 2021. So now let's move forward to see what changes have been effected by way of this new labor law. Next slide, I guess. Next slide, please. Yes. So employment contract. In the old labor regulations, there was two types of employment contract. One was unlimited term employment contract, and other was limited term employment contract. So by way of introducing this new labor regulations, the new labor regulations, it has uniform the employment contract. So this unlimited contract that have been abolished, there is no concept of unlimited term contract right from the effective of this new labor regulations. And there is only one type of employment contract is available, that is limited term employment contract, and that is for a maximum tenure of 3 years. Of course, it can be renewed. It can be renewed for another period of 3 years or for a shorter period as per mutual agreement between the employer and employees. And all the existing unlimited term employment contract as on the date, it will it need to be converted into fixed term, into limited term employment contract within a period of 1 year from the date of implementation of this new regulation, that is till 1st Feb 2023. Next change that have been initiated, that is probationary period. As we all know, the initial 6 months for any employment arrangement, that is termed as the probationary period. It is not mandatory that employee need to be on probation period for 6 months only. It can be lesser period as well, but it cannot be more than six months of the initial employment arrangement. So that time period of 6 months probation period, that has been retained in the new labor law as well. However, certain changes have been made. Earlier in the old regulations, employer, in case if the employer wished to terminate the service of any employee during the probation period, then it was allowed. Employer can do so without giving any notice. Now in the new regulations, the interest of the employee during the probation period has been protected, and now if an employer wishes to terminate the services of any employee during the probation period, then employer can do so by giving a notice of 14 days. Similarly, in case of if an employee wishes to terminate the services during the probation period, then employee can do so. There are two scenarios. One, in case of expat employee, if the expat employee wishes to go back to his or her home country, then such employee can terminate by giving a notice of 14 days. But such employee cannot come back for another employment within 3 months from the date of his or her departure. And in case if the employee wishes to take up another employment within 3 months from the date of his or her departure from the UAE, then the new employer is under obligation to compensate the previous employer towards the cost of recruitment. Second, in case if the employee during the probation period wishes to join another employer, then within the probation period, then the employee is supposed to give a notice of 30 days, and again the new employer is under obligation to compensate the previous employer towards the cost of recruitment. So these are the changes regarding the probationary period. Next slide. Working models. Some new working models have been introduced. Rather, I would say expressly incorporated in the new labor regulations. In the previous labor regulations, it talks about full-time working model. Although the Ministry of Human Resource, by way of Ministerial Decree number 31 of 2019, it has introduced the concept of part-time work model. So it was very much permissible part-time work model since 2019. But despite the fact, it was not expressly mentioned in the main regulations. So now in this new regulations, this multiple working model have been introduced and expressly incorporated in the new regulations. Full-time, as we all know, full-time means an employee is eligible to work for one employer only on full-time basis. Part-time means an employee can work more than one employer, and part-time employees, they are eligible for the annual leave. They are eligible for the end of service gratuity as well. Temporary work model means in case the employee is engaged for a certain period, certain durations, or for some undertaking some specific project. So you can say it is just a synonym of the fixed term employment contract. Remote work, of course, we all have seen it is of the global recognition during this pandemic period. So during this pandemic period, government by way of notifications, it has allowed the remote work. Now it is still permissible, remote work with the consent of the employer. Flexible work model means where the hours of the work, days of the work are not fixed. It is flexible and it depends on the volume of the business. So these are the working models that have been introduced in the new regulations. Next is working hours. Working hours in the old labor regulations, the working hours was mentioned 9 hours a day. So it has been reduced. Now the maximum normal working hours shall be 8 hours per day. However, the overall cap on weekly basis that has been remained same as 48 hours per week. But in case of some extreme emergency situation, to prevent any accident, to prevent any damage, or in case of work which is of such a technical nature which requires excess working hours, then in that case this cap of 48 hours it will be increased to the 56 hours per week. And of course the same provision during the Ramadan, as we all know, the working hours need to be reduced by 2 hours, and an employee shall not be allowed to work for more than 5 consecutive hours without a break. So that will be of 1 hour break. And for the clarification purpose, this 1 hour of break period or interval period, it will not be included in calculating the working hours. Now, some changes have been made for overtime. Overtime, in case of some exigency, business exigency, employer can request the employee to work beyond the normal working hours, subject to maximum of 2 hours per day. And in this case, the overall time limit, overall working hours has been capped 144 hours for 3 weeks. And the method of calculation of the overtime wages, that has been revised in this new working regulations. In case of overtime, it will be calculated on the basis of basic wage with the increased 25% of the basic wage. So you can say at the rate of 125% of the basic wage. And in case if the employee has been requested to work between 10 p.m. to 4 a.m. or any holiday or any rest day, then the method of calculating this overtime wage, it will be calculated on the basis of 50% over the basic wage. So this was about the working hours. Next is the annual leave. This Article 29 of the new labor law, it talks about the annual leave. See, the annual leave, it is the same in case if the employee has completed 1 year of continuous service, then employee shall be eligible for the annual leave of 30 days for each year. And similarly, if the employee has completed more than 6 months, but less than 1 year, then employee shall be eligible for the annual leave for 2 days for each month. Now, under the old regulations, there was no concept for forfeiture of the annual leave. So annual leave cannot be forfeited. It can either be carried forward or it can be encashed under the old law. In the new regulations, they have made certain changes. In the new regulations, the employee must use his or her annual leave during the year of entitlement only. And employee may carry forward not more than 50% of the annual leave to the next year. However, subject to agreement and suggestions of the employer may agree to carry forward the annual leave for maximum 2 years, not more than that. And part-time employees, I am also seeing there is a lot of question coming for the part-time employees for annual leave. Annual leave for the part-time employees are eligible for the annual leave on pro rata basis, on proportionate basis. Maternity leave. Maternity leave, earlier in the old regulations, it was for 45 days. Now it has been increased from the 45 days to 60 days. The first 45 days shall be fully paid basis, and next 15 days shall be on half pay basis. And a female employee shall be eligible for the maternity leave even if she has delivered a still child, dead child, or even if the infant dies immediately after the birth. So even in that situation also, she will be eligible for the maternity leave. Similarly, sick leave, there is another provision for the sick leave. No, previous slide, yes. There is a provision for sick leave in case if the female employee suffers from any sickness or illness, and that is solely caused because of pregnancy, then she is eligible for 14 days unpaid leave. Earlier it was 100 days, now it has been reduced to 45 days. And in case if the female employee delivers disabled child or sick child, then additional leave of 60 days shall be granted, 30 days on the paid basis and 30 days on the unpaid basis. And there are another provision in case when the female employee resumes her work, returns to the office, returns to the work, then she is eligible for nursing break, 2 nursing break per day, not more than one hour, and till the time the child has attained 6 months. Earlier this was 18 months, now it has been reduced to 6 months. So she is eligible for the 2 nursing break as well. So this was about the maternity leave. Some new type of leaves have been introduced in the new labor regulations, like parental leave. Parental leave means it is over and above the maternity leave. It can be enjoyed by both mother and father, by both the parents, and it is allowed for 5 days over a period of 6 months from the date of birth of the child. And bereavement leave, compassionate leave, it is again newly introduced leave, and it is eligible, it is allowed in case of death of the spouse for 5 days, and 3 days in case of death of other close family members. Sick leave provision, it was already there, so 90 days sick leave is allowed, 15 days on full pay basis, 30 days on half pay basis, and 45 days on no pay basis. And during the probation period, employees not eligible for the sick leave. Study leave. Study leave, it is again newly introduced leave. An employee who has completed 2 years of service in the organization and who is attending some recognized academic institution in the UAE, and such employee shall be eligible for the study leave for 10 days in a year for sitting in the exams. So this was some new leaves that have been introduced in the new labor regulations. So that was part of end of my presentation. So now I would like to request my colleague Ms. Sakina Dikanwala to take you through the remaining part of the slides. Thank you.
Thank you so much, Mr. Pandey, for these interesting insights. And I would like to welcome Sakina Dikanwala, who is an associate partner for our legal division here at MBG Corporate Services. I think she is a well-known face. She advises multinational clients on a wide range of aspects relating to commercial law in the UAE, of course, the new labor law, business restructuring, commercial agency and distributorship, employment matters, and regulatory and compliance matter. Among other areas, she advises clients on AML, international transactions, company formation and joint ventures, company liquidation, economic substance regulation, DIFC data protection law, and corporate governance. So Sakina, over to you for the second part of the session.
Thank you so much, Lydia and Mr. Piyush, and a very good morning, everyone. So, as Mr. Piyush has highlighted, there are with this new law, the UAE's position in the global market has been strengthened, as ease of working and attraction of new talent will definitely be there with the new introduction of the regulation. So now, without taking much time, let me dive into my today's topic to now start with termination under the new law. So when we talk about termination, the notice period is should not be less than 30 days and not more than 90 days, which is more or less there in the old regulation as well. And if any of the party wants to terminate, then they don't want to give the sufficient notice which is being mentioned in the contract, then payment in lieu of the notice needs to be given to the other party. Also, if the employer terminates the employment contract, the employee is entitled to receive 1 day unpaid leave each week for search of the new job. This is something very new provision which has been mentioned in the new regulation. Also, in terms of termination, as in the earlier regulation, there were 2 types of the contracts, limited and unlimited contract. In case of unlimited contract, be it a notice being given or not given in the first period of 2 years, years, there was a breach, it constituted a breach of the contract, and there was a penalty of 45 days from the employee side and 3 months from the employer side was being there. But now this provision has been removed and completely been changed with the new regulation. And the contract types also, as Mr. Piyush Pandey already covered, that has been unified also. So now talking about termination in more detail, next slide, please. So reasons are being categorized into 3. So with notice, definitely when the parties are in agreement for, ending the contract, they can do so by having a mutual agreement. Also, there are other reasons like workers suffering an incapacitating disability, or a written notice has been given, and bankruptcy of the employer. So these are some of the cases wherein with agreement, both the parties can end the contract. Now, what are the clauses with respect to ending the contract by the employer without giving any notice? So earlier also under Article 120, there were some reasons being there wherein without notice an employer can end the contract, which is more or less same in the new regulation, wherein if employees committing any violation of the contract or any fraud is there, or revealing any trade secrets which has resulted into the loss in employer's business. So these were the ground, and also this requires a written investigation prior to termination. Also, one of the case wherein there was a default from the employee and the employer wants to terminate, then the notice was supposed to be given, the notification to the ministry was supposed to be given within 48 hours. Now this notice time has been increased to 7 working days. So these are very reasonable changes which has been made under the new law. Now, talking about from the employee side, there are some cases wherein employee exposed to serious danger, harassment or assault. In this case also now ministry needs to be informed within 5 working days immediately by the employee. Then this constitutes a reason for termination without notice. Also, if employer breaches any contractual obligation. Now, in this case, the ministry needs to be notified prior to 14 days by the employee. Then this ground will be constituted for termination without notice. An employee required to engage in substantially different location or place, so which was not been agreed in the contract. So this also constitute a reason for termination. Next. Now, moving further, let's discuss what are the provisions with respect to gratuity, as we are receiving a lot of questions with respect to the calculation of the gratuity. So the gratuity calculation has been made now unified for both the contracts, which is different from the earlier because 2 types of contracts were there. So mainly for limited contract, there was a provision if the employee is completing the contract tenure, then 21 calendar days was applicable for first 5 years, and then 30 calendar days for from the 6th year, which is now been made unified because there is only one type of contract. And in the earlier contract, there was a provision for unlimited contract wherein if employees resigning, then 1/3 calculation was there between 1 to 3 years of the tenure, and 3 to 5 years, 2/3 calculation for the gratuity period was there, which is now being unified. Also, there is one clarification in terms of the gratuity that for the existing contract, if now within 1 year it does not get changed and the employee is resigning or being terminated, then the provision of the old regulation with respect to unlimited contract will be applied. This is a clarification from the ministry. Now, the total amount of the end of service gratuity must not also exceed the total salary of 2 years pay, which has been there now in the new regulation. And resigning and dismissed employees entitled to full gratuity if employed for over a year. So means eligibility remains the same, which will be after completing the 1 year. The end of service payment also is required to be paid within 14 days of the termination of the employment contract. So this is something new which has been there in the new law, as there was no such period specified in the earlier law that when the payment of the end of service gratuity must be made, which is now been clear that within the 14 days. Moving further, let's discuss non-compete clauses. So non-compete clause was also there in the in the old version of the labor law, and now it's being there in the new labor law also. But there are some changes in this regard. So basically, Article 10 of the UAE Labour Law states the non-competition in the new labor law. It provides that the clause must be specified in the employment contract to be effective. So this condition was also there in the previous law, that the non-compete clause is very important, that needs to be specified in the contract itself. Also now it must be limited to time, location, and the type of work to the extent necessary to protect the legitimate business interest. This is something new in the new labor law. And also the new labor law provides that the non-compete shall be for the maximum period of 2 years. So now with this, you cannot make the non-compete for more than 2 years. Less than 2 years is allowed, but not more than 2 years. So these are the main changes wherein even employers are required to, determine the territory, location, time, etc. for putting the clause of the non-compete in the contract. Moving further, there are some new initiatives which has been mentioned in the new law. So equal pay for equal work should be there. Also prohibition of discrimination on the basis of religion, race, color, or sex is there in the new regulation. Provision is there with respect to sexual harassment in the workplace. So this is very interesting provision wherein you need to put all these conditions in your policy. Also, the committee is being formed wherein these kind of cases are being reported to the management. So there will be a new practice being developed for reporting the sexual harassment cases. Also, a new provision regarding repatriation of employees' body in case of death to its country has been mentioned in the new regulation. How we can help you with respect to complying this new regulation. So this is basically a way forward for the companies. So existing contracts needs to be carefully assessed, wherein amendment of the unlimited contract to the limited contract needs to be done. Now the period is up to 3 years. So currently also when we make the contract, the period which has been there in the ministry is 2 years, but definitely there will be a realignment of the period for up to 3 years, which has been there in the regulation also. Also, the companies are now required to make the employment handbook as per, or they need to revise the existing handbook as per the new regulation. There was no mandatory provision in the earlier regulation with respect to the company's policy. So mostly the companies were following the labor regulation in case, there was any governing provisions were there with respect to the employment. But now there has been a mandate in the law itself to make the employment handbook or work regulation which governs the employments within the organization. And the change of the contracts must be done within the period of 1 year from the promulgation of the implementation of the law. So now the companies should comply with the law, and definitely this will be, a very reformative step wherein the employment environment will be very healthy and will grow in future. So on this note, I would like to end my presentation and looking forward to answer the questions in the Q&A session. Thank you.
Thank you so much, Sakina. And as expected, we are getting in a lot of questions. So in the interest of time, I have picked 4 questions during the session. I will address 2 to Mr. Pandey and then 2 to you. So Mr. Pandey, there's a question whether the existing contracts will be governed by the new law or the old labor law?
Existing contract means existing unlimited contract. See, there is a time period that has been given for 1 year, so during which this need to be converted. But of course, it will be governed by the new labor regulations, because new labor regulations has been repealed in entirety. So if there were certain provisions, if it were specifically mentioned that certain provisions of this old labor law, it will continue to effect, then probably it would have been governed. But since it has been repealed in entirety, it means no provision of the old regulations is in existence. So that cannot be invoked. So only a provision which is prevailing and existence on a particular date, only that provision can be invoked. So it means it will be governed by the new labor regulations only.
That's clear. Thank you so much. Sakina, Manoj is asking how the provision of sexual harassment will be implemented in companies.
Very interesting question. So as I mentioned that first of all, the companies are required to make a proper policy which will address these kind of cases. In addition to that, as a practical approach and aspect, the companies can also form a committee wherein female members can also be part of the committee, and this committee can hear out the cases with respect to sexual harassment, and accordingly, they can tackle this matter.
Thank you. And then I think Piyush, we are getting this question in quite often. There are a lot of queries regarding part-time employees, and I believe you have addressed this question during the webinar, but I will ask it again. The question is how the provision of annual leave and gratuity will be applicable for part-time employees.
Yes, I think this is a very common question. Most of the people, they are raising this concern. So I will explain it, how it will work. In case of part-time, of course, the part-time employee, they shall be eligible for the annual leave as well as end of service gratuity. Then I will try to explain it, how they will be eligible and how it will be calculated. Part-time employee, they will be, normally they will be engaged on hourly basis. So suppose an employee who has worked for entire year for 240 hours in the entire year. Now, this total working hours, this need to be calculated in the number of days. So this total 240 hours, it will be reduced to the number of days by dividing from 8. So it means the part-time employee has effectively worked for 30 days in a year. Now, what is the total working days for the company? Suppose the organization has worked for total 300 days in the year, and the part-time employee has worked 30 days. So it means on proportionate basis, effectively the contribution of part-time is 10% out of the total number of working days. Now, in case if the part-time employee, if that employee were full-time employee, then during a particular year, he or she would have been entitled for 30 days of annual leave for an entire year. But since the particular employee has worked for only 10% of the total working days, so it means employee will be eligible for 10% of annual entitlement. That is 10% of 30 days, 3 days. But in the new regulation, they have put a cap. It will be minimum 5 days. So 10% means proportionate basis or minimum 5 days, whichever is higher. Similarly, same calculation will happen for the end of service gratuity as well.
Thank you so much. That's much clearer. And I'm taking one last question, Sakina. I'm seeing it quite often popping up in the chat box below. The question is the employee who has a managerial position entitled for overtime and holiday pay?
Yes, so basically, so now there are two aspects of the question. One is the overtime and the pay. So holiday pay basically. So overtime, definitely it is not applicable, which was there in the previous regulation also, that those holding the managerial position and above are not entitled to receive any overtime pay. Holidays, definitely it is applicable to them. So the leave entitlements are same for all the employees, which has been there in the old regulation and the new regulation.
Okay, thank you so much. That brings us also to the end of the session, and I would like to give a special thanks to Mr. Piyush Pandey and Mr. Sakina Dikanwala for taking our time today and providing these very insights on the new labor law. We are still getting in a lot of questions, but as promised earlier, we will reach out to all of you individually on the same. In the meanwhile, if you have any question, please feel free to contact us either at uae@mbgcorp.com or 052-640-6240. And this webinar will be also uploaded on our YouTube channel, so make sure you subscribe it so that you get an auto request once it's live. Thank you so much for attending today's webinar, and we're wishing all the attendants a wonderful week ahead. Have a nice day. Thank you.
Thank you.
Thank you. Thank you, everyone.